Greetings, everyone. My name is Howard Gould. I am co-chair of the real estate section for the Beverly Hills Bar Association, um, and happy to have everybody joining us today for our program on negotiating commercial leases for small tenants. Before we begin, I'm going to let you know what some of our upcoming programs are and make a couple of announcements. Next week on July 2nd, we're doing a program on the Davis-Sterling Act, which of course is the act that governs most homeowner associations. Michael Kushner is the speaker for that event about practical aspects and some of the basics of the Davis-Sterling Act. We're doing a second program in July on the 25th, which is going to be about landlord insurance for lack of habitability claims in landlord-tenant cases. Very often, lack of habitability is raised as a defense, and there is a possibility of insurance coverage. And Steve Raucher, former president of the Beverly Hills Bar, is going to give that presentation. And Steve's area of emphasis, obviously, is insurance matters. We're going to do a program that's a little unusual for us on August 20th. It's sort of a litigation theme. CCP section 664.6 on settlements has been revised. There's some specific things that relate to probate law and family law, and certain things that practitioners need to know when they're settling things. And of course, a large number of real estate parcels end up getting transferred through both probate and family law matters. Al Provinciano, the incoming president of the Beverly Hills Bar, is the speaker on the family law aspects, and Scott Rahm is going to talk about the probate aspects of 664.6. On September 17th, we're anticipating Larry Jacobson again doing a review of the 2025 important real estate cases. And in October, we anticipate a program on SB 79, the transit-oriented housing development statute that is going to change the face of places like LA by allowing larger scale developments near transit-oriented developments, often bordering single-family residential neighborhoods. In terms of today's program, you can find a link to the program materials in the chat if you haven't already downloaded those. And we aren't going to use the chat for questions and answers. Those will go in the Q&A section, which I'll monitor as we go through and attempt to raise the issues from the Q&A at appropriate places during the program. Your MCLA certificates, are sent out very promptly by the Beverly Hills Bar, so you should look for those soon after the presentation. It's my great privilege to have Bryan Mashian joining us again this year. He's lectured for us the last couple of years on AIR lease forms and AIR purchase and sale agreements. Always a great pleasure to have Bryan here. And this year he's put together a program that is not going to run you through the forms, but it's really how to negotiate a commercial lease for small tenants who obviously frequently don't have the leverage of larger tenants, and give you some practical strategies and some of the common pitfalls. Bryan is the principal of his own firm, the Mashian Law Group, where he represents institutional, mid-size, and entrepreneurial clients in office, retail, and industrial real estate transactions. This includes leasing, subleasing, purchases and sales, and other transactions. Bryan spent 20 years at the Buchalter firm where he was a partner. He is currently chair of the contracts committee of the AIR, American Industrial Real Estate, Commercial Real Estate section. AIR is an association of commercial real estate brokers that publishes leases, purchases, sale contracts, and listing agreements. And they have a library of more than 70 contracts that are now published in all 50 states. Bryan was previously chair of this real estate section of the Beverly Hills Bar for the executive committee, putting on programs like this one. He was previously on the steering committee of the commercial development and leasing subsection of the real property section of the Los Angeles County Bar Association. He speaks at the International Council of Shopping Centers, a lot of people know as ICSC, at their conferences, and he was on the editorial board of the Shopping Center Law Report. Bryan has written numerous articles, sends out some very interesting articles by email from time to time, and has obviously had numerous speaking engagements. Bryan's undergraduate degree is in economics and political science from UCLA. He also got his law degree at UCLA, where he was an editor of the Law Review. Bryan, thank you for joining us.
Thank you, Howard. Thank you for having me join you today. Let me share my PowerPoint and let's make sure I'm doing it correctly, Howard.
Yes, it's on the screen.
Perfect. Thank you. So, this I find to be an interesting topic. I attended a seminar on this topic as a younger lawyer, and I think the challenge of doing a commercial lease for a small tenant is still there because what what we have to do as a lawyer for negotiating a small lease is really limited by quite a lot of factors like um, the the leverage imbalance. Typically, the small tenant doesn't have the kind of leverage that it would require to negotiate a lease to make it a fair or a more balanced lease because it's a big project. The tenant has a small portion of the overall project, and the landlord doesn't have the patience or the desire to negotiate a lease with a small tenant. And the fact of the matter is, most commercial leases start as heavily landlord oriented because it's the landlord who prepares the contract. And the landlord often presents the same form lease to a small tenant as it does to a large tenant. So a small tenant has to really overcome a lot of obstacles that a large tenant has the budget and the time and the incentive to do it. The same issues are presented in both situations. If you're a small tenant dealing with a landlord form, it's the same issues. It's the same 200, 300 plus issues. Uh, and the fact is that the small tenant can just be damaged proportionately as much as a large tenant if the lease is not negotiated properly and its interests aren't protected. So the challenge from a lawyer's perspective is that the small tenants usually don't have the bargaining leverage, like I just mentioned. The small tenants don't have an in-house counsel or the legal budget. They come to the lawyer and say, "Look, I want to open a business. I don't have a lot of money to spend on lawyers. I have this much money," and that's really the budgetary constraints that you have to work with. And also, a lot of the small tenants don't have the operational sophistication that the larger tenants have. The larger tenants have a staff or they have a uh, um, infrastructure which deals with construction and the things of that nature. Whereas a small tenant, they handle everything on their own, and they don't have the financial flexibility as a large tenant. And I've seen many small tenants oftentimes sign a lease as is presented. I mean, a lot of the AIR leases, I got to tell you, they get signed quite often as they're presented to the tenants by the landlord. It's a printed lease. Tenants look at it and they say it says standard on top. They read the business terms. They look at it and they say, "Wow, it's printed. It says a standard. I don't really know how to understand this lease and it looks right." Okay, they go look at the addendum that a few points that they negotiated are in there, and oftentimes tenants sign it. And then the problems are manifested later when they run into problems during the course of construction, during the course of operation, etc. So, from a lawyer's perspective, it could take you 20 years or more to build a reputation as a good lawyer, but 20 minutes to ruin it because if you do one bad deal, and I often say, it's that one small thing that you didn't want to really do, but you did, and it ends up going badly, and it could end up creating a lot of negative noise about the lawyer. So you really want to be either turn it away and say, "I don't want to do it," or if you do it, you got to do it right. And uh, the from the being the lawyer for the tenant, it's critical for the lawyer to really focus on the important issues. As a negotiating a large lease, I have the luxury, and most lawyers have the luxury of having a checklist, having the addendum that you can go, or you redline and send back the lease, and you present couple of hundred issues, and you work through the issues laboriously with the other lawyer, with the landlord's lawyer. So what what it really is the challenge is to focus on what's important, and it may be counterintuitive, but it's almost better to have a more senior lawyer who has the experience and the knowledge of what's important, what's unimportant. It's maybe better to have a more senior lawyer do the small lease rather than a junior lawyer, but I think the economic realities of our business is such that oftentimes the younger lawyers are given the smaller leases to negotiate. That's because their hourly rate is less or for whatever other reason. So what's happened now with with the introduction of artificial intelligence, we have a new reality in these negotiations. It is pretty typical for a client to run the lease through AI before they come and talk to a lawyer or even after they talk to the lawyer. The AI has really radically changed the client's approach to leasing. The AI will summarize the lease, and the difficult to understand legal language of the leases are summarized and simplified by AI, so the clients have a better understanding of what the lease provisions mean. It interprets and explains the clauses. Clients can ask questions, follow-up questions. What does this mean? No, I don't understand that, and AI will explain. There's lots of programs out there, and there's just basically some AI that's readily available to the public as well that will suggest edits. The AI will point out obvious risks in the transaction, and it will identify, depending on what the prompt is, hundreds of issues, right? It depends on what the client asks AI to do, and it can identify many, many issues. But AI still struggles with what is market. The market is king in any transaction, and even a small tenant can have leverage in this down market where it's a tenant market or it's a buyer's market, and the tenant can have leverage. And it's not something that I think that, of course, you can ask AI, do I have leverage, etc., but I don't think that AI has a real-time sense of that. And the market leverage assessment is a very critical thing to have in the back of your mind as you're negotiating. And that's very important to identify what truly matters in the deal with the market, and also finding out from the client what is important to the client. That's really where the rubber meets the road here, is to spend the time with the client to understand what are their key pressure points and make sure you cover those. And the other thing that AI still struggles with is the negotiation, the psychology and the strategy of the negotiation, which is obviously much more significant in a larger transaction, but it's still there with a smaller lease. And AI has also impacted the lawyer side of the transaction. Like Howard said in the beginning, forms used to be very important. Our practice, the real estate practice, is heavily forms based. But with AI and the sheer amount of information and forms and templates that are available publicly, a lawyer having his or her own form is not as important. And maybe it's going to be gone soon. I doubt it. I have my forms. I still keep them. I use them as a resource. There are many resources like the CEB, PLI, many other sources where lease form books and resources are available. So gone are the days where people used to create their own forms. You can still use them through the AI and other publicly available sources. One thing that I especially like in negotiating a small lease is to use the AI feature of having a Zoom meeting with a client, discuss the lease, go through what's important with them, and then have AI record and summarize the client discussions. That actually simplifies the one part of the roles, role of the function and role and function of the lawyer in the transaction. Because I think as a lawyer in lease negotiations, you really have two sides or two adversaries you need to be concerned about. One is the landlord, and the other one is your client. You need to protect yourself against both. So if you advise the client to do something and they decide not to do it and not follow your advice, then you need to be able to document that. And AI is a fabulous tool for being able to very easily record and summarize the client discussions. So what are we talking about? What is a small lease? I'd say it's somewhere between the size is about 3 to 5,000 square foot. The term usually runs from 3 to 5 years, maybe with 1 or 2 5 or 3 year options to extend the term of the lease. The rent will run anywhere from 5 to 10 grand a month, and the condition of the space is usually the way it is pre-existing with little or no tenant improvements. And I'm not going to talk about work letters or TI allowances today because it would just not be enough time. But that's a significant issue, and it's typically not a heavily negotiated item with the small leases that we're talking about today. So the thing that I think
I would note, Bryan, that you just
sure.
recently sent out an article about how the work letters or the TI improvement provisions and how that really is it's a separate contract within the lease itself and the importance that it can have.
Yeah, that's a three-part newsletter that I did the first part this month, and the second one is coming out next week. And it's about really how a work letter or even the work letter makes it sound like it's not as important of a part of a lease, but it's really a construction contract. And the reality is there's a lot of money that's spent by both sides in the work letter. So that needs to be really paid attention to and heavily negotiated if necessary. But like I said, we're talking about a hypothetical small lease where the tenant improvements are not that significant. So to negotiate a lease on behalf of a small tenant, you really need to ask, as a lawyer, the three questions. Is this point important? Yeah, I bring it up in every lease. Is it obtainable? Is the landlord going to even entertain my discussion? And is it worth spending the political capital on? Because a landlord or landlord lawyer will turn off the tenant or the tenant's lawyer if you ask too many questions. And if you have way too many comments, they're just going to tune out the lawyer or the tenant. So you really, I think, have to be very mindful of picking your battles. Make sure you only present the issues that are critical. And this was an interesting challenge for me to come up with my top 10, 12, 13 issues. And here's my picks. The first one is the base rent. Obviously, not the amount of the rent, because that's not my job as a lawyer. That's the broker or the client's choice. But the rent is based often on the size of the space, and the size is oftentimes wrong. That's just the reality of our business. And sometimes it's wrong unintentionally or unknowingly. Actually, in the AIR contracts committee, we're having discussions about how do we solve or eliminate. I mean, I don't think we can eliminate. We can reduce or mitigate some of the risk that's created by virtue of the fact that most transactions end up using wrong size information. And it's important to discuss that with the client because the size of the space obviously directly impacts the base rent. And if it's a multi-tenant situation, it affects tenants' pro rata share of the common area expenses that the tenant pays. So it's a quick, easy discussion with the client to say, have you measured the space? Or do you have any idea of how big is the project and your sense of it? And obviously, it's much more difficult for a tenant to measure a big shopping center or an office building. But the most important thing is to actually bring up the topic with the client so that I've covered my neck and I've told them about making sure that they verify the size. Now, measurements are much easier to do nowadays because of the technology, laser, lots of different ways. I was doing an industrial lease and I told the client that they should measure, and they went on Google Earth and they used the Google Earth images, and they were engineers. They could figure out based on the picture, and they triangulated and figure out what the size of the roof was. And then they said, look, we're satisfied. It's close enough. And I felt like, okay, I did my job. And what's important is to really tell the client to measure the space before the lease is signed. And like I said, it's much easier to measure now. If it's not possible practically to measure the space because, for example, there's a new demising wall that's being put in, so you actually don't have the exact configuration of the space, that's a perfect opportunity to ask for a right to measure the space, let's say within 90 days after the commencement date. Once the demising wall is up, and say we want to have a right to measure, and then we're going to retroactively and prospectively adjust the rent based on the verified square footage. So that's something that affects how much the rent is paid throughout the term of the lease. So I consider it to be a significant issue. The next significant issue, I think, is obviously taxes, insurance, and CAM charges. No big surprise here. The problem is that if the lease terms are negotiated, and then the lawyer tries to change or negotiate some of these what the business people consider business terms, then you're fighting an uphill battle. So it's important. Sometimes I get a call from a client, hey, I'm thinking about leasing the space. Uh, what do I do? And I think it's important as a lawyer to tell the client, let me see the letter of intent before you finalize it. Because yeah, it's very important and it's a smart strategy to use the LOI stage to negotiate the business terms. Some of these business terms that can become obviously negotiated at a later point. Try to fix the economics before you go to the stage of drafting the lease. A lot of times brokers or the suppliers will say, "Oh, we'll handle it in the lease," or to be determined or to be discussed in the lease. That often means that it's too late for you as a lawyer to try to do something about it. One of the things that I ask for is the landlord's billings for the current year to date and the prior 2 years. It's very important to get that information. Oftentimes, I see that brokers do not ask for this information when they're negotiating the business terms. So it's very helpful for the client to see what those billings are. Then they get a much better idea of what their actual total occupancy costs are going to be once they sign the lease. It's also very interesting that if you get billing records or billings that are professionally prepared, they look right, they look great, then you're more likely dealing with a landlord who's going to manage their building well. If you get something that looks like it was just recently put out of, they pulled it out of a shoebox and they're just giving you something, or they say we don't have it, then that should be ringing the alarm bells to make you think, okay, well, we really need to make sure we deal with the operating expense, the taxes, insurance, and this issue very clearly because it's the landlord is probably not handling it properly. So this issue really manifests in the single tenant versus a multi-tenant occupancy. This issue shows up in two different sections of the lease. If it's a single tenant, there's typically a provision for taxes, another one for insurance, and then the maintenance, repair, and replacement of the premises. It falls into three different sections of the lease. The multi-tenant occupancies, all of these are lumped together on the operating expenses or CAMs or, they all fall into one pool of operating expenses. I've seen also some industrial landlords in a single tenancy will bill taxes, insurance, and they choose to do the maintenance repair themselves and they bill it as operating expenses. So sometimes you see even a single tenancy where there really is no common areas, the landlords will try to manage the maintenance obligations by having operating expenses paid for by a single tenant. What's important is to ask for the right to audit. Tell the client, hey, you do not, as a matter of you don't have an implied right. There's no cases that I've seen. If somebody has seen it, I mean, the last case was the Octagon Plaza case, which interpreted an AIR lease, and that tenant was told by the court, no, you don't have a right to audit in the lease. So, and I'm not aware of any California cases which give a by law, right to audit common area operating expenses. But it's good to ask to make sure you told the client, and it's not often that a small tenant would get the right to audit. What's really sad is that sometimes I get the right to audit and the tenant doesn't use it. They just don't care. Their eyes, they're focused on running their business and they don't really pay that much attention to the CAM bills. They get it, they pay it, and then they move on. So, but it's good for you as a lawyer to make sure you ask the landlord for the right to audit or tell the tenant, do you want to have the right to audit? So property taxes is the single largest item of operating expenses for most real estate. And in California, obviously, we have the Prop 13 regime where the change in ownership triggers a reassessment of the property. And a Prop 13 protection whereby the tenant is not obligated to pay the increase in property taxes due to the change in ownership of the property is a very critical thing to even talk about. Are you going to get it? Not if it's, I seldom get it. And it's a very hard fought battle because it directly affects the value of the landlord's property when you reduce the net operating income of the property after sale. So it's very seldom that a small tenant will get a Prop 13 protection, but it's important for me to bring it up to the client to tell them, look, this is something that's very important because you have no control over when the landlord sells, how much they sell it for, and then you're gonna potentially you can have a sudden large increase in taxes, and there's no way around it. You have to pay it. So this is something that I make sure I bring up, even if the brokers tell me, hey, you know what, we tried it. I talk to the client at least, and I make sure I record and I make a record that I talk to them about it. And in the single tenant leases, obviously, it's also good to get the right to contest taxes. And if you have an option to extend a fair market rent, if you have a base year operating expense arrangement, like in office leases, I want to make sure that with the market rent adjustment, the base year for taxes gets reset because that's a big protection for a tenant who stays in an office building for, let's say, 5 years, and then they exercise an option. The rent goes to market, and then they get a new base year. The other thing that I talk to the client about property taxes is if I say, let's ask for Prop 13 protection, and if the landlord says, look, we have no plans to sell, which is not atypical. We say, look, if you do decide to sell, give us a right of first refusal to buy the property. So at least we're not just paying the high taxes without getting some benefit. So it's sometimes an idea that a client likes because as an owner user, they're able to get very favorable SBA loans with very high loan to value ratios of 90%. And sometimes the user is the best buyer for the property, and maybe the landlord will give him a right of first refusal to buy the property when they say no to a Prop 13 protection. So that's a good thing that's like a fallback to ask for and have a discussion with the client about it.
2 points here, Bryan. I mean, I
Yeah,
like that right of first refusal. Um, this is a point where the lawyer may have a role that the broker won't take on, which is to talk seriously to the tenant about how long their lease should be, and also have the tenant talk to other tenants if it's a multi-tenant building, because those tenants may know more than the landlord is going to tell you about what the landlord is actually doing in management, what their plans are, whether they're going to sell. And if they're going to sell soon, it may be that tenant wants a 3-year lease and not a 5-year lease, but the broker's interest is having a longer lease, and they may or may not seriously discuss that with the tenant. But if they really think the landlord is going to sell and they're going to get hit with Prop 13 increases that could be very large, they may prefer a smaller lease with an option.
that's an excellent point, Howard. And I think there are lots of fallbacks to deal with Prop 13. The tenant can negotiate a one-time exclusion or two-time exclusion of change in ownership. You can negotiate a dollar cap on how much the tenant will pay for the increase in taxes. You can negotiate a percentage increase. So there's lots of creative ways to address the risk that's created by the change in ownership and the sudden large increase in property taxes. But what's really important is, again, to bring up the point with the tenant, because a lot of times it's not brought up and the clients don't think about it. The brokers may not bring it up either. But this whole discussion of property taxes really needs to be done in context. And as a lawyer, you got to ask, well, like exactly what Howard was saying, how long is the lease term? If it's a short-term lease, then it's not going to be as significant of an issue. If it's a long-term lease, if you have a 25, 30-year lease, then there's a much higher likelihood of having a change in ownership happen during the term of the lease. The other component of this assessment is really to figure out how is the current assessed value in relation to the current market value. If the same ownership has held this property for many, many years and the current assessed value of the property is significantly below the current market value, and if there is a change in ownership, then you're going to have a large increase in property taxes, and the tenant can't maybe they can't afford that and they can't budget for it. So these are two good questions to ask and have a discussion with the tenant about to find out how concerned are they about this risk, which is beyond their control. It's also important to think about what is the reimbursement, operating expense reimbursement arrangement? Is it on a net or a base year deal? And obviously, if it's a base year, depends on what the base year is, and if it's a net, then the exposure doesn't really make a difference because the tenant pays it all. But if you have a base year, that's, for example, if you're doing a lease in 2026 in the middle and you negotiate a 2027 base year, then you've got some protection if the sale happens in the 2027 year, then the tenant, a lot of the increase could be absorbed in the base year and it may not be passed through to the tenant. So that's another thing to look at. The other thing to look at is if it's a base year, how is the base year defined? Sometimes the lease is defined based on a fiscal year, sometimes based on a calendar year that the lease is signed. So those are subtleties at this point that you should look and discuss with a client. Insurance. Now, obviously, everybody knows what's happened to the insurance industry in California after the Palisades fire. And one of the things that I always tell the clients to do is to send a lease to their insurance broker or insurance risk manager, have them look at the lease provisions to make sure that they can, in fact, provide the insurance that's required of them and how much is it going to cost. They need to have an idea of what is the premium for the current coverage that they're required to provide. And that's an easy thing to tell the client to do and get a bid, get an idea of what the cost is going to be. And increasingly, landlords are asking tenants to have higher and higher coverages, 5 million, 10 million, even for 5 million, even, it used to be 1 and 2, now it's 2 and 5 or with an umbrella. So these coverages are creeping up and they're getting more and more expensive. And the ratings and the fact that the insurance provider has to be admitted in California. We had a lot of the admitted carriers leaving, but now seems like they're coming back. One of the issues that I also bring up is the earthquake insurance. Typically, the tenant is required to reimburse the landlord for the commercial general liability insurance and the fire insurance. And on top of that is earthquake insurance. Earthquake insurance, as we all know, can be very expensive and it has a high deductible. And one of the things that I get as part of getting the current billings by the landlord is, does it include earthquake insurance? And if it doesn't include earthquake insurance, then I say, okay, if you're not carrying it now, I don't want to pay for it later if you decide to carry it. And if they're carrying it now, then I try to negotiate a cap on the tenant's contribution of the earthquake insurance, because that is, again, something that could very easily increase exponentially after an earthquake and something that the tenant can't really budget. So it's important to have that discussion as well with the client. So the other CAMs kind of, they usually fall in a pool of operating expenses. And as a small tenant, I've never had the leverage to negotiate a line item exclusion from the definition of common area operating expenses. And even if you do as a lawyer succeed in negotiating a line item exclusion of certain expenses from the definition of operating expenses, the reality is that when the landlord bills it, there's no way the tenant can know if they are actually not being charged for things that were negotiated in the lease without doing an audit. And seldom does a small tenant want to bother with doing an audit. They don't have the budget, they don't have the time. And the operating expense provision of leases is one of those provisions that a lot of lawyer time goes into negotiating, and oftentimes it's not adhered to by the management or the administrative staff. They typically send out their billings in the same fashion to every tenant in the building. They don't seldom I've seen the landlord's management and accounting staff goes through the lease and make sure that they adhere strictly to what the items that were negotiated to be excluded from definition, their typical standard operating expense definition. This has been such a problem that Prologis came up with their what they called a clear lease. It was supposed to be a shorter lease to reduce negotiation time and legal costs. And what Prologis did, they said, let's combine the base rent with a fixed charge for operating expenses. And they thought that they would achieve their goal of giving the tenant cost certainty, and they would eliminate CAM reconciliations and also negotiation of CAMs during the lease discussions. I don't know how successful that was. I've negotiated a Prologis' clear lease, and obviously I've negotiated it, so it does shorten it, but probably not as much as Prologis hoped. Westfield is another company that they will sometimes include CAMs, cap it as an amount, and include it as part of a fixed amount that the tenant will pay along with base rent. That was also meant, but again, with the same idea of reducing the legal fees to negotiate operating expenses and reduce or eliminate the CAM reconciliation headache and the staff. The easiest way for a small tenant to approach this issue is to negotiate a cap on operating expenses. And ideally, you want a cap on all operating expenses. The problem with that is that if the landlord agrees to a cap on all operating expenses, that includes a cap on taxes. And that, again, is a major concession by a landlord. They don't want to cap the tenant's contribution to taxes, because if they do decide to sell, then that inability to recapture the increases in taxes will affect the value of the value of the property. So usually the cap I've seen is on controllable expenses. So then and one of the questions becomes, is the cap compounded or cumulative, which is a very important question, because if you negotiate a 5% cap, is that 5% based on the first years, or is it on the prior years? And what happens if the 5% cap isn't reached in one year, but the next year the increase is actually 7%? Can you go back and recoup some of the cap that wasn't captured in one year? That's a good discussion to have with the client. Obviously, goes right to the bottom line. From the lawyer's perspective, you got to really take a very close look at what's the definition of controllable. That's where the battle becomes in. Typical landlord definition of not controllable is taxes, which is, again, that's something that they don't control. If they sell it, you could say, well, no, it's controllable. You decide when to sell. But I've not seen taxes typically be included in what's controllable. Insurance, again, is not controllable. Utilities, security expenses are somewhat, but then you run into a problem where, as a tenant, you want the landlord to provide the requisite security for the safety of the shopping center or the office building. But then they say, well, if you want us to do that, then you have to let us charge what's appropriate, put the right staff, get the right equipment. So there's a tension there in trying to put security expenses in controllable expenses. Capital expenses, usually that I think that's an easier battle, because that gets amortized over the reasonably expected useful life of the capital item. Cost to comply with laws. Usually there's an exclusion for cost to comply with laws which were violated as of the lease commencement date. Management fees really are controllable, because they're usually around 3, 4, 5%, and it's not something that the landlord cannot control. So those are the major components of what gets negotiated in controllable operating expenses. The next topic, to me, is assignment of subletting. Is a very significant issue, because it affects the tenant's ability to sell the business, retire. If you're negotiating a lease for a doctor or a professional, what if they get sick, they die? What if the business wants to be handed down from the first generation, or the business is downsizing, or wants to merge with a bigger company? So the assignment of subletting is the governor for all of those. And I think it's absolutely critical that to insist on the tenant's ability to assign or sublet with landlord's consent not to be unreasonably withheld. Now, most of the time, I see the leases start out with that provision. In California, there's not too many leases that I've seen where the landlord says they can absolutely withhold. They absolutely prohibit transfers or the transfer is subject to landlord's arbitrary consent. The one thing that's important to pay attention to is to eliminate the recapture right, especially for retail and industrial tenants, because they end up having a significant amount of money invested in the space, whether it's machinery or, and equipment, or the retail tenant is dependent on that particular location's visibility and access and signage, so they really don't want to lose that location. So I remember this one client came to me. She had a very successful pretzel kiosk in one of the local regional centers, and she had a tenant, somebody who wanted to buy her business. She went to the landlord and said, "Sure, sure, good. You want to sell? Just ask us for our consent." She never looked at her lease. I think she didn't even look at it when she signed it. She didn't look at it when she was going to sell the business. So she goes to the landlord and says, "Yeah, I want to sell my business. I want your consent." And the landlord says, "Great, now we're going to cancel your lease." And she was so distraught because here she was going to make $400,000 selling her business, and it went poof up in smoke. Fortunately for her, the recapture right was not well drafted, and we were able to negotiate some kind of a pretty good settlement for her, and she was able to still do the sale and get most of the value of her business. But you got to really focus on the recapture right. The other thing to focus on is eliminating any adjustment to market rent on a transfer. That's a killer because a lot of times the small business's value comes from having a certain amount of cash flow. And if the rent adjusts to market, that means the cash flow for the buyer is going to be a lot less and the buyer's not going to pay as much. So that's important for the buyer, for the tenant to eliminate adjustment to fair market rent on transfer. Quite a lot of leases have the indirect transfers restrictions. You know, if it's a LLC corporation or partnership, they put a 25% or more change in ownership of the entity is considered an assignment. So it's important to have as high a threshold as possible, 51% or more. Critical to exclude the sale of business, because if the business is sold as a stock sale or an asset transfer, you really don't want to have any of those, either the recapture or the change to market triggered. Preferably, you want to have the ability to sell the business and not go through the regular lease provisions, which require tenants to submit lots of information, and the landlord can sit on things for up to 30 days sometimes. It's also critical to exclude from indirect transfers, the entity transfers, the transfers of the beneficial ownership between the initial owners or to their affiliates. The affiliates transfers is a pretty standard one, but I don't know how significant it is for a small tenant because typically they don't have affiliates. They usually just sell the business. Profit sharing is very prevalent in the landlord leases, typically calls for 50-50 split or 75 to landlord, 25 to landlord to tenant. You got to look at how long is the lease term, how often is the rent adjusted, is there really a likelihood that the market rent is going to be above the contract rent, and in either situation, it's important to exclude the sale of the business, the goodwill, the assets. None of that should be considered as part of the profit that the landlord is going to get any of it. And quite a lot of landlord-written profit-sharing provisions include those items. What's very important to a small tenant is the transferability of the options, especially extension options, which are very typical in leases. And most leases, the AIR leases, Section 39, they make the options non-transferable. They make it personal to the original tenant. And if the option is not transferable, that could really significantly affect the tenant's ability to sell its business and get the highest market value for it, because the buyer wants to make sure that they have the right to continue to occupy and operate the business at that location. But with a personal non-transferable option, the tenant is unable to market the space and get the most money for its business. So it's important to negotiate for the transferability options. Ideally, you want the options to be freely transferable. Seldom are you going to get that. And I think a reasonable compromise is for the the option to be transferable to an assignee that's approved by the landlord, and hopefully a consent by the landlord can't be unreasonably withheld. Quite often, you see the tenant's ability to exercise the option is subject to the tenant not being in default and being open and operating. These are ways that the landlords try to take back the options that they really didn't want to give, but they gave to make the deal. So from the tenant's perspective, depending on how likely it is that the tenant is going to sell, or some other provision which is going to trigger the assignment right, you want to eliminate these conditions to the exercise of the option, and or have a right to cure them. Anyway, the transferability is critical to the sale of the business, especially if the lease term extension option is at a fixed price and not market.
Bryan, in those situations, if it's really the crucial issue to the tenant, can they sometimes, enter a bankruptcy and still have the right to make the transfer as a result of being in bankruptcy?
Yeah, I'm not a bankruptcy lawyer, but there are as you're saying, Howard, there's bankruptcy provisions that trump retail leases. I don't think it applies to all leases because there's some bankruptcy provisions that allow the bankruptcy court to override the lease provisions.
Right.
Personal guarantees is the one I also focus on because quite often the tenant will be operating through a corporation or LLC, and they end up giving personal guarantees. What they don't realize is that the guarantee continues even if they sell the business. A lot of business people don't appreciate that. Yeah, they could sell the business, but their company is on the hook, and so is their guarantee. So I make sure that we have a discussion with the client, or try to negotiate an end to the guarantee once the business is sold to a buyer who is approved by the landlord. And that's a critical thing for a tenant. I've had tenants who say, look, if I'm going to continue to be liable, I don't want to sell the business. I don't want to have the downside of that. So it's important to make sure the client appreciates their continued liability under the guarantee. There's lots of ways the guarantees can be negotiated. The good guy guarantee, which basically says the guarantor's obligations go away if the tenant doesn't pay rent and the tenant voluntarily vacates the space, so it doesn't force the landlord to file an eviction and drag the landlord through an unlawful detainer. It's important to also discuss with the client, maybe you want to have burn-offs on your guarantee. If you have a 10-year lease, your guarantee should start to burn off after a year or 2 or 3 once you've been a good tenant. That liability should start to go down because you've now proven yourself. Or put a cap and have the cap go down. It could be a stated dollar amount of cap, or it could be a rolling 12-month cap. The other thing to explore is using security deposits instead of guarantees. Some clients will prefer to give 6 months security deposit instead of giving a personal guarantee. And some landlords are willing to make that horse trade. They figure, okay, if I have 6 months, that covers me for the rent and the turnover costs and blah, and I'm okay not getting the personal guarantee. So that's a very good discussion to have with the client. The next section that's important, which is the maintenance, repair, and replacement section. From a tenant's perspective, this provision is typically very broadly written to make the tenant responsible for both structural and non-structural portions of the premises. So I try to, by a few words, limit the tenant's obligations to the interior non-structural portions of the premises. That way I'm excluding the foundation, the floor and ceiling slabs, the roof structure, curtain walls, columns, those major expensive portions. So I just try to limit it to the interior non-structural portions, and also try to avoid being responsible for the replacement of the building systems, mechanical, electrical, fire, life safety, plumbing, the sprinkler system, and the HVAC. If you can't eliminate it, maybe you can say, okay, the landlord replaces it, and you amortize it over the reasonably expected useful life of the item, and the tenant pays his pro rata share of that cost for the duration of the lease. I think this slide brings up an issue that comes up quite often in leases. It's the roof that needs to be repaired or replaced, the asphalt parking, the paving has worn out, the HVAC needs to be replaced, or one of the utility mains breaks. The utility mains are very expensive. These are the expensive items that the tenants get upset about having to pay for. The roof membrane is, again, these are something that a tenant should do an inspection before signing the lease, get a good idea of what's the current condition at the lease inception, so they can go to the landlord before signing the lease and saying, look, your roof is on its last leg. I'm not going to pay to replace it. You need to be responsible for replacing it. Or the asphalt paving has lots of cracks, so you need to take care of it. And the HVAC is something that I routinely tell clients, get an HVAC guy, not just a general inspector, because they do a much better inspection of the HVAC. They go check the compressor. You get a cheap report on the current condition, the expected useful life of the HVAC. That inspection easily pays for itself. And HVAC units can be very expensive, and it's either you eliminate or you ask the landlord to amortize the replacement cost over the item's reasonably expected useful life. And that's something that the clients really appreciate, because that really ends up being an expensive item. Let me see. The condition of the space at the beginning of the lease. Pretty commonsensical, but a lot of landlord leases don't say what the tenant really reasonably expects the space to be in. Like the tenants expect that these items are in fact exist, but the lease says, hey, the tenant takes it the way it is, as is, whereas with all faults, whether known or unknown. And it's important to have the tenant again do an inspection. And for the tenants, from the tenant's lawyer's perspective, this is not too big of an ask. I think it's within the reasonable expectations of normal business people to say, okay, if you're going to lease a space to a tenant, it should be in the condition so that the tenant can conduct its normal business operations. So obviously that comes down to the construction of the physical improvements. So you want to make sure that's all done before the lease starts and the tenant has to start paying rent. The compliance with applicable laws is an important one, especially today's we have these professional plaintiffs who are ADA plaintiffs. They sue. I don't know how many people have gotten by without getting sued. It seems like everybody gets sued by an ADA plaintiff, whether you're a landlord or a tenant. And it's something to really look at and have a discussion with the tenant. Do you want to do an ADA phase? Do you want to do a CASP inspection, a certified access specialist professional inspection? And what's really important there, if you're in a single tenancy, is to make sure that the van accessible handicap space with the blue striping and the placards and all that stuff is there. And the only way to know that is to have a CASP inspector do the inspection, write up a report, send it to the landlord before you sign the lease, and say, hey, look, the space doesn't have the ADA required parking spaces or path of travel. We're going to get sued. I don't want to pay for it. So you spend the money to bring the parking lot, not the inside, the parking lot, the access ways, the path of travel up to compliance with ADA.
On the other hand, you can have issues with even your front door or build outs that are not compliant with the ADA. And you don't want to have to make those changes if you're leasing a space that wasn't compliant when you leased it.
Absolutely. Absolutely. And it's not just paying the money to fix it, but it's settling the lawsuit. You pay anywhere from, I don't know what the going rate in the market is, but it's really the tenants get so upset because it's basically they feel like they're being blackmailed to pay money and then fix it. And but that's something to have a discussion. I oftentimes go on Google Earth. I look at the space before the client signs it. I look for some of the obvious signs of ADA compliance. I look at the roof of the building from the satellite pictures. You'd be amazed how much you can learn just from looking at the Google Earth. And these are questions that you can bring up. If you see ponding on the roof, if you see the tree branches coming over the roof, you can tell the client, look, there's going to be problems with the roof. You need to get that addressed before we sign the lease.
Again, you want to advise them to talk to their neighboring tenants if it's a multi-tenant building.
Absolutely. The other thing that's important, getting a phase one report is not as critical for a retail or an office building. Usually there's not as much of an environmental, but with an industrial use that has some chemicals or some processing of chemicals, it's very important to have that discussion with the client to make sure that the client understands their potential liability under federal and state laws for hazmat and recommend to them that they pay for a hazmat or ask the landlord for a phase one. It's important to have the discussion. Maybe the client opts to say, look, I don't want to pay the 2,500 or 3,000 it costs today to do a phase one. If they have a clean use, maybe that's okay. But from the lawyer's perspective, again, you're covering your neck to make sure you told the client to get it. The other thing that's important to make sure that the condition of the space satisfies at the lease commencement date is to make sure the building systems and utilities are available and operational. Ideally, you want to get some kind of a warranty from the landlord, for example, that the HVAC is going to be working for this at least 6 to 9 months, so that the building goes through at least 3 out of 4 seasons, and the tenant turns on the heating and the cooling out functions to make sure the HVAC works. You want the roof to go through at least one measurable rainfall so that you can determine whether the roof leaks. So these are things that this all depends on what is the client's expectations. Parking spaces, critical, obviously, to most businesses in LA and California. You want to make sure your parking spaces for your customers and employees are available and accessible, and you have access to the premises 24/7. So my last item is the permitted and exclusive use. From the tenant's perspective, it's important to negotiate for as broad of a permitted use as possible. This is important for giving the tenant the right to assign or sublet with less restrictions, because in California, a legitimate basis for a landlord to deny consent to a proposed assignment or sublease is that the proposed assignee or subtenant's use is not permitted in the lease. So if the lease provides for a broad use, then that makes it easier for the tenant to assign or sublease. If it's a narrow lease, then you have to fit within that narrow permitted use in trying to assign or sublease. It's this is an important impact that it has on the landlord's right to reject the transfer. For retail tenants, obviously, exclusive use rights is a discussion that you must have with the client. It depends on what their business model is. Do they care for competition? Some tenants want competition because they actually like to have somebody's similar use nearby. Some don't. So this is something to discuss and see if you want to negotiate an exclusive use right in the shopping center. Obviously, you have to look at all the other existing permitted and exclusive uses to see how valuable the exclusive use rights that you may be given. This is also an important issue for the future evolution of the business. If the business grows or the tenants, for example, wants to pivot from being a Mexican restaurant to a Chinese restaurant because the Mexican concept didn't work. So the use has to be broad enough to permit the tenant to pivot like that.
We have some questions, Bryan, that I'd like to
Yes,
run through with you.
please.
One question is, have you ever been able to get a most favored nation clause in a lease for a tenant?
Not for a small tenant. For a bigger tenant, yes. But for a small tenant like this, honestly, it's not something that I think I can get, and I don't have the leverage for it.
So the other sort of difficult question is, what happens when you get a landlord and they just say no to all of your requests for the small tenant? Do you have anything that you can do in those situations?
First thing is to make sure that I've done my job. Look, we're lawyers, we're not guarantors, we're not insurance companies, we're not here to we're advisors, right? And I think one of the things that we got to keep in mind is that a lot of these points that we raise ultimately become business decisions. What we do is make the client aware of the fact that here's an issue, here's a risk. We've asked for it. The landlord says no. If you've tried the compromises that you know, and then you're getting shut out, market is king. Like I said, market is king.
One of these business decisions, I knew a broker who got sued once when they were showing somebody, I think it was a large industrial property, and then they showed him another one across the street, and the client decided to rent the one across the street, and then they found out it was in a different jurisdiction that had a business tax that the other one didn't, and the broker got sued over this
Wow.
issue. And it's not really a legal issue, and it's more of a business issue, but it's something people don't think about is to check what the rules are in the jurisdiction where they're going to lease, especially in Southern California, where you have so many jurisdictions and you often don't know where one starts and one ends.
That's an excellent point.
We had another comment here that someone had a landlord refuse to honor the assignment and was requiring a new lease from the purchaser of the business. So that sounds like sort of push comes to shove on a legal issue.
Yeah, it's an interesting question because if you're trying to assign the lease, and let's assume for our discussion that the landlord was duty bound to be reasonable. That's a completely different discussion and analysis versus negotiating a new lease. Because then there's no duty to be reasonable in negotiating a new lease. When the tenant wants to assign the lease that it has, the landlord has to be reasonable. And as a tenant who's selling, you have to be very careful to make sure you don't give up your rights and your claims against the landlord for being unreasonable. And sometimes that situation happens because the tenant doesn't want to be responsible for the lease after they sell the business. They rather the new person sign a new lease, so they're off the hook. So there's the trade-off, and it happens quite often. And if you have been unsuccessful in negotiating a release of liability on sale of the business, then unfortunately that's what you're stuck with.
Another question is what clause can you negotiate or try to include in the event the landlord goes through a bankruptcy or a default on a loan and there's a possible foreclosure? Because I think, obviously sometimes if you have a recorded loan that's preceded the lease, your lease could be wiped out by that foreclosure.
Excellent question. And this is a risk that's prevalent that exists in small leases, large leases, and if there's a loan that predates the lease, and exactly like you said, Howard, if the loan is foreclosed, that terminates the lease unless the tenant signs a subordination on disturbance and a torment agreement with the lender before they sign the lease. And that's the solution, is to make sure that the tenant is not dispossessed on a foreclosure. This is especially important if you have a client who's going to come in and spend a lot of money of their own money. If they're going to spend their own money improving the space, if they're going to spend millions of dollars improving a space and there's a loan on there, you want to make sure that you get it on disturbance as a condition to the lease commencement date. Because once the lease starts, you start paying rent. Good luck trying to get the landlord to get you that SNDA. They don't care anymore. So what you want to do is you want to make sure that you get the SNDA as a lease commencement date. I remember years ago, I negotiated, the landlord wouldn't give us the SNDA before we signed the lease. And I said, okay, for every day that you're late beyond a certain amount of time, then we get a day's free rent for the delivering the SNDA. And it was very ironic because hundreds of days went by and we actually ended up accumulating a lot of free rent. But my client at the end of the day said, I don't care. We got the SNDA. I don't want to upset the landlord. I want to have a good long-term relationship with them. I don't want to do a gotcha. But you got to build the motivation and an incentive for the landlord to get you the SNDA. So you got to do it either before the lease starts and you start paying rent, or build some kind of a penalty or some kind of a.
Hopefully the lender will agree that as long as you're going to torn to them, that they'll let you stay at whatever the rent is you've negotiated.
Yeah.
Somebody did note 11 USC 502 BC regarding, I think, the bankruptcy issue on the claims for commercial leases. One or two other things we just wanted to mention. You really want to inquire about special circumstances for your client. Especially if you're talking about lawyers, doctors, other people where the business is completely reliant on that one or two people. How old are they? I have had senior doctors where I was able to get the landlord to agree to a retirement clause. And if, as long as they gave 6 notice and they were leaving the practice of medicine, they could terminate their lease. And that was very, very important to them under the circumstances where they were maybe in their early 60s and, maybe had health issues or other things like that. And it brings up the question of all the things you talk to your client about at the beginning, their age, their business timeline, how long they think they're going to be in business, what expansion they may need, because if they need it and they can't get it, now they have a big problem. You already mentioned the parking is sometimes a major issue, and you assume you're going to always have the parking you see at the beginning, but sometimes there are other changes made in the property, and for retail tenants, sometimes the storage is an issue. And one of the things that it's great to tell people in any real estate transaction, leasing, buying a house, anything else, is what are the assumptions you're making, and go
Hmm.
talk to your neighbors. Even in buying a house, go talk to the neighbors. You'll find out interesting things sometimes about what's going on in the area. And of course, the other thing, big issue sometimes is the signage. Um,
Yeah, those are
all,
excellent points.
yeah,
What I say, I do these presentations for brokers, and I tell them, and I'm going to tell the same thing to us as lawyers, is we only get into trouble, and no, you only get sued because the client was upset and disappointed. They didn't get what they want. And I think the critical thing is to make sure we understand what are the hot points for the client. And exactly what you said, Howard. How long is he going to be in business? Does he have a succession plan? They're going to sell. All of that is a discussion to have, and it's not so much. We got to stop the knee-jerk reaction of going to a checklist or going to a form or an addendum that I use and see if I can just walk it through and make a bunch of comments. That's really not it. That's not where it's at.
And the final point that I would make on this, which you've touched upon in part, is that when you have a business and it has multiple owners, which sometimes is the case, you need to talk to them about how these lease obligations are going to affect things if they have an internal buyout, if there's guarantees and
Hmm.
somebody it says, okay, it's time to buy me out. And then they say, well, wait a minute, I'm going to still be stuck on the guarantee and I'm going to be relying on how my former business partners run this business and whether they pay the rent and things like that. And so when you have multiple, in a sense, multiple clients, because there's multiple owners of the business, sometimes it's tricky to think about the things you really need to ask them about.
Yeah. Now, how many law firms had personal guarantees by the partners who had left and they were still on the hook for guarantees of the lease?
When Finley Crumble years ago crumbled, I had a friend who was nominally a partner, really didn't get treated like a partner, but he was liable for their leases when the bankruptcy happened. And Brobeck Flager, I always heard that they ended up, which was a really, really old line San Francisco firm, that part of the reason they disappeared is they took too big and too expensive a lease in Silicon Valley. And sometimes leases, and I know of a large retail operation in my hometown in the Midwest where the younger generation expanded into some very expensive leases, and then the economy went bad, and those leases brought down all parts of the business in a sense because they had overextended and they didn't separate the entities to keep the loss of the new expensive leases from dragging down the old successful part of the business. So
Yeah.
a
Yeah.
lot of considerations, and it's a great topic. And thank you so much for doing this, Bryan. Very interesting subject and a lot of earned wisdom that you're imparting to everybody.
I appreciate it. Thank you, Howard, for having me.
Thank you, everyone, for attending.